Gorton.
First, for Ms. Garvey and for Mr. Manno, knowing that you're fully aware of your oath, our first question is, to your knowledge, did the FAA possess any information regarding a terrorist plot to hijack aircraft and to use them as weapons on targets in the United States, or any other plot that resembled such an operation prior to 9/11?
Commissioner, in my knowledge, from my perspective, we had no knowledge of that.
Mr. Manno?
No specific knowledge, certainly not in the way that the events were carried out on 9/11.
Ms. Garvey, as you know, we had a long relationship between 1997 and the year 2000 when I was chairman of the Senate Subcommittee on Aviation and you headed the FAA. There were a significant number of hearings during that period of time. Would you characterize those hearings as primarily related to competitive issues, to airport capacity, slots and landing slots and rights and the like, to aircraft safety from the point of view of the rules that you adopted with respect to aircraft safety, and to the extent that they dealt with security exclusively or almost exclusively on the subject of explosives on aircraft?
Commissioner, I think that's a fair characterization. I would add one caveat, and that is the economic issues really was the domain of the Department of Transportation, but certainly capacity, explosives, safety issues, those were FAA and certainly had a number of hearings.
The demands for a passenger's Bill of Rights, for example.
That's correct. That, of course, would have been more DOT as well.
And those subjects were also the primary subjects of the Gore Commission, whose recommendations set many of the boundaries for concerns during the years, at least that I was there, up until the year 2000. Is that not correct?
I would agree with that assessment, Commissioner. Yes.
Is it fair to say, with respect to security issues as well as to security issues, is it fair to say that there were more pressures on the Federal Aviation Administration to relax security measures during that period than there were to strengthen them?
I'm not sure I would fully characterize it that way. If you're asking me, was I aware that industry or others, for example, had concerns about some of the security measures? Absolutely. We certainly.
That's exactly what my question is.
We certainly heard it through the rulemaking process. We certainly heard it in public meetings that were held. You know, I do want to go back, though, to a point I made in my opening statement, and that is, while the public and certainly Congress as well was very focused on the capacity issues, which were very real at the time in 2000 and 2001. We still had a security office with very experienced, very well-trained professionals who were focused on those issues as well.
But outside pressures on you and your office were primarily focused on those other subjects, were they not?
That is correct, Commissioner.
One example of these security matters, you saw the knife that was circulated during the course of your testimony, which now at least we all can draw a breath at how lethal it was. Can you say why it was that a knife of that size and potency was universally considered to be something which could regularly be carried onto aircraft? Was there a great deal of pressure, for example, that anyone should be able to take a Swiss Army knife with him or with her on an aircraft? Were any of the rules, were any of the suggestions in this 5-year rulemaking that had not been completed directed at weapons of that nature?
I don't remember that discussion when I was the administrator. I can give you a little bit of perspective, at least from my perspective. As you indicated, that policy was in place on 9/11. It was a policy that had been in place that is prohibiting knives larger than 4 inches. It is a policy that, is my understanding, had been in place since the 1970s. But again, if you go back to 9/11 and you think about the atmosphere in an airport, knives were very commonplace. Knives were used as part of the meal service in the airlines. If you were to stop at a security or a souvenir shop, even beyond the secure area, it is possible that you could purchase a pocket knife and so forth. And from the security, intelligence experts, from the law enforcement people, the greater threats, as has been indicated even by the staff report, the greater threats were from larger, more lethal weapons and from explosives. Clearly, with the benefit of hindsight, as you pointed out, we have a different view. I do think it is important to remind ourselves, as the staff statement reminded us, that we are and we're dealing with an incredibly intelligent, well-trained, disciplined terrorists who may have used any other number of common household items as a lethal weapon as well.
And who just flat out beat us.
That's right, Commissioner.
At our May hearing, you testified, and I quote, that perhaps the greatest lesson of September 11th is that the terrorist threat is just as real here at home as it is for our embassies in East Africa, a naval destroyer in Yemen, or the Marine barracks in Beirut, end quote. At least in retrospect, should not that have been the lesson of the 1993 World Trade Center bombing?
You know, I think with the clarity of hindsight, you can look at a number of those facts and come to those conclusions. And you know, again, I do want to go back to a point that has been made earlier. There was a growing domestic concern, and I think that was reflected in some of the intelligence circulars, some of the SDs that the FAA issued. So there was a growing concern, but I think the greatest thrust, the greater concern was still international. Should we have learned more from the World Trade Center? Boy, again, I think with the clarity of hindsight, there are certainly questions there.
With respect to intelligence, and Mr. Manno can comment on this question as well, explain to us how it was that you had a no-fly directive that applied to only 20 or so people, while there was a terrorist tip-off list that included hundreds or thousands of people. Were you, Ms. Garvey, aware that there was such a tip-off list? Did Mr. Manno, did your section have that list available to it? Did it even know that it existed? And if you did know that it existed and had it available, why weren't those names on a no-fly list?
I think I can answer that by explaining the way that the process worked. As I indicated earlier, the way that we received intelligence or information from the intelligence community was by identifying our statement of intelligence need. Based on that, the intelligence community provided us information that was relevant to aviation security. So based on the information that we received, our analysts reviewed it. And in the case where there was specific and credible information that people were actually targeting, making plans to target civil aviation, if we had identifying data, they were put on a security directive, which directed the air carriers not to transport these people.
All right, but neither of you have answered my question. Let's break it down and ask it again. Were either of you aware of the existence of the tip-off roster?
Yes.
Were you Ms. Garvey?
I may have been aware. I can't tell you with certainty that I was aware pre 9/11 that the list.
Well, were the names on that list then available to you and not requested, or available to you and discarded as not important?
Commissioner, if I could, I'll give you my perspective and then turn it over to Mr. Manno. But from my perspective, the names that I saw, and we'd see them in the security directive. They would be included in the security directive. From my perspective, those names were the names that the intelligence community believed had some implication with aviation. So, for example, while other intelligence agencies may have had other names, those names pre 9/11, if they did not have a specific aviation.
I fully understand that, but my question still is, were those names not supplied to you, and I guess this is for Mr. Manno, or were they supplied to you and discarded as not having a relationship with aircraft?
Tip-off at that time included about 61,000 names. We had access to tip-off, but the way that it worked is if you had a name, you had to have a name, you could then go against tip-off and do a search, and it would provide you information. But the way that the system worked at the time, unless we received the intelligence reporting that identified to us names of interest, and then to go into tip-off and search against that, it was simply not used that way. So tip-off was there, tip-off was available, tip-off was 61,000 names that included information from not only of terrorists involved in all sorts of things and others.
And it was perfectly all right to have them fly, because they were terrorists and other things. There was no reason to put them on your watch list, right? I mean, I don't understand the logic of this.
Well, the way that the process worked with the security directive is names were identified to an airline, who then bumped those up against their reservation list to determine if somebody was actually going to fly.
Yeah, that's right, but you only had 20 names that fell into that
Yes.
category. And there were thousands of names on a tip-off list, all of whom were suspected terrorists. And so I gather the decision at some place or another was that a suspected terrorist who had not specifically been linked to aircraft was okay to fly.
The names, including the 20 names, were names that were specifically identified to us in intelligence reporting. The process was for the intelligence reporting to indicate to us those that we ought to be concerned about.
And you made no further inquiry beyond that? You didn't ask for a list of suspected terrorists?
You mean through tip-off?
Yes.
No, we did not go to the State Department and ask them to give us all 61,000 names so that they could be put on the watch list. For one thing, the airlines would not have been able to handle such a list.
Well, they weren't given the opportunity, were they?
Well, we know that today, sir, because today we're managing a similar list, which is of about 3,500 names, which requires the carriers to check against the reservation system, and they're struggling just even with those.
Well, they sure have no trouble handling their frequent flyer lists. I mean, that's ridiculous. Your whole testimony it talks about process. You've described to us, it sounded like an indoctrination course for your new employees, describing the process. What about common sense? Did you ever step back and say, no, look, my job is not to wait till the intelligence community gives me finished product, but to look at this and say, does it pass the common sense test? Does it pass the common sense test to let young Arabs on with 4-inch blades? Didn't any of you, leadership is about not taking the process, which you hide behind, but about saying this is not sufficient. Of course they can handle thousands of questionable people. Of course young Arabs should not be allowed on airplanes with 4-inch blades. Yet none of you applied common sense.
Yep. I want to, Secretary Lehman just said that's right, you know, every time I fly, every time I make a reservation, I get a frequent flyer credit. the airline has no difficulty in doing that for me to check my name against its list every time. I can't see how it has a problem with 3,000 or 60,000 suspected terrorists. But let's leave, you answered my first question, I think, accurately, that as of 9/11, you did not anticipate or expect, you did not imagine the kind of hijacking that actually took place with suicide and the killing of many people in mind. Let's accept that. But certainly, with respect to all of the hijackings that have ever taken place before, you were anticipating and were working against the kind of hijacking that went to Havana or that asked for the release of prisoners, or the like, and yet you never, either of you, and I guess this would apply to Admiral Flynn as well, decided to have an expanded no-fly list of suspects. Is that correct?
The list at that time was based on specific and credible information that we had.
The other two? Any answer beyond that?
I regret to say that I was unaware of the tip-off list and was unaware of it until yesterday.
This is the list. And these guys, some of these guys had associations. That's the list.
Now, one other thing. Are you saying, you who are current today, that there are only 3,500 people on a no-fly list today?
There's actually two lists, a selectee and a no-fly list, and actually the number is greater than that.
What is the relationship between the FAA at the present time and the tip-off program?
Well, as you know, tip-off has now been rolled into the TSC process.
Okay.
So the way that the system works is that we obtain information from that list, and people are put on the no-fly list based, again, on indications that they pose a threat to aviation.
But merely being a suspected terrorist doesn't get you on that list.
Pardon, sir?
Merely being a suspected terrorist doesn't get you on that no-fly list.
It can. It depends what group you're associated with and what other information there is.
Wow.
As an example,
I find that to be an incredible answer.
As an example, there's a lot of information that came out of the war in Afghanistan when the camps were discovered there, lists and things like that. And those names, because of their ties to Al-Qaeda, are put on our no-fly list.
Well, I must say I would strongly suggest that when the intelligence agencies of the United States have a name that they expect or suspect to be a terrorist, that name ought to be on the no-fly list. And I think, in my view at least, that's a no-brainer. Back to you, Ms. Garvey. Does the FAA, or did the FAA, have any kind of supervision over flight training schools? Obviously, to license a pilot requires a certain degree of education, but is there any monitoring of the schools at which young men and women receive that flight training?
Commissioner, for the flight schools, there are standards and requirements that a flight school would have to attain in order to get an FAA certificate. And depending on the level of training they are providing, those certificates would vary.
But that certificate goes to the school. That just says you do a
exactly right,
competent
Commissioner,
job.
and that's exactly
but
right.
There's no connection. The school doesn't have to report the names of the people who are taking the training or the degree of training that they've received to you to check against any kind of license application?
Pre-9/11, there was no vetting of the individual students who signed up in the schools.
Is there now?
Yes, there is, Commissioner. Post 9/11 there, and as part of the legislation, and even before that, as an emergency action, there is vetting of the of the student and an actual verification that the school must receive and submit to the FAA from the country, from the student's country.
Ms. Garvey, as the administrator, how much of your time did you spend on security matters? How often were you briefed, for example, by people like the Admiral or Mr. Manno? How did you get performance ratings of civil aviation security policies through the airlines and the airports and the like? What share of your time did it take, and what was your function in connection with it?
Let me divide it, if I could, Commissioner, into two parts. One is, how did I receive the sort of security information? And number two is, how did we monitor sort of the day-to-day progress being made by security? And I'll start with the second part. Security, like safety and efficiency, was responsible for establishing goals and objectives. And in this case, it centered very much, has been indicated, around some of the rulemaking, some of the explosive detection machines, and so forth. That monitoring and oversight of that really occurred as part of management board meetings that were held on Monday and Friday. As to the security information, how did I receive it, and so forth, as Mr. Manno indicated, there were on any given day, or there could be as high as many as 200 intelligence facts received by the intelligence office. I would certainly not receive every one of those, but anything that the intelligence office deemed important would come up to my office. If there was a particular urgency around an issue or something that the associate administrator was particularly concerned about, that I would receive that briefing in person, or if I was not in the office at the time, I would receive it perhaps later in the day from perhaps the deputy secretary. So I would receive security briefings either through a written document that would come directly to my office, or through an oral direct briefing from the associate administrator.
The staff reported on the checkpoint operations guide that was developed by the air carriers and approved by you as the head of the FAA. To your knowledge, was there any airline that ever was restless or objected that operations guide was too lax and wanted or imposed itself more stringent regulations on on passengers?
I'm not aware of that, Commissioner.
Finally, I think it's someone else's turn here, but the 9/11 families submitted what I consider to be a very important question to us, to which I'd like your answer. How is it that when you went through your various proceedings dealing with violations of federal law on the part of airlines, and imposed fines, that in fact, on average, the fines were reduced to 10 cents on the dollar? Why is it that when you go through an entire system and say a fine ought to be so many thousands of dollars, but that just isn't the end of it?
Well, if I could, Commissioner, I'll answer, and certainly if other panel members want to contribute to this. First of all, I'd like to check the number. I'd heard that before, and I've not had an opportunity. I'm not sure that that number is correct, but I'd like to check it. And I can certainly tell you that from the FAA's perspective, or from my perspective, the civil penalties that we imposed were not as effective as we wanted them to be. We went back repeatedly to get those fines raised, and they were raised incrementally. I think we were far more effective when it was levied against individuals than when it was levied against a company. Frankly, I think sometimes we found the best way or sort of the best, the more effective way was to publicize that, and we did that. But there's also the due process. The inspector or the special agent who first brings the action forward submits that, and there is also, of course, the due process where the lawyers for either the individual or the lawyers for the airline goes through the process with the FAA, and a determination is made. I don't know if it's 10 cents on the dollar. It was
that's
never
a
as
lot
high
of
as
due,
we'd like
that's
to
a
have.
lot of due process to go to 10 cents on a dollar. And I guess we would appreciate it if you have the ability to do so, since you question whether or not that figure is accurate. To the extent of your ability to answer that question more precisely in writing later, we would very much appreciate it. I think I do have some more questions, but the red light's been on for some time, and it's Congressman Romer's turn in this connection.